what this case is about?
John?
Let's start with John Berlinski.
Sure. So I guess big picture, this is a profit participation. It's a litigation stemming from a profit participation audit. And so what you have is you had an audit, you had numerous different claims that were included in an audit report. You had the filing of a litigation, and essentially the self-dealing claims were directed to arbitration by the state court judge. And so what you have, big picture, that has been litigated thus far in arbitration is you basically have certain self-dealing claims that were brought, big picture, in connection with network license fees, the initial network license for the television series Bones. So essentially the self-dealing transaction between Fox's studio and Fox's network was that licensing transaction for seasons 5 through 8. Was that consistent with the promises that Fox's studio made to profit participants in terms of the adequacy of the license fees that would be put into their profit participation pool? Secondly, you had issues that were self-dealing issues in terms of international self-dealing licenses. So when Fox, the studio, goes and distributes the television series to its affiliates overseas, be it in England, be it in Spain, be it in Italy, they have networks that are located over there, cable networks. Were those deals, did they meet the self-dealing standards in the parties' contract? And then the third big bucket was in connection with Hulu. So Hulu, as many of you know, is at the time was essentially fairly close to 50% owned by Fox. The streaming rights to the television series Bones were licensed from Fox over to Hulu. And so again, you had the same self-dealing questions of, in connection with those licensing transactions, did Fox, the studio, meet the standards that it had promised the participants in terms of those licensing agreements being fair to the participants? So essentially that's kind of big picture.
So the case started off in the Superior Court, but it didn't end up there. What happened? Case started in the Superior Court, but ended up in arbitration.
Yeah, so we, Aaron and I's firm, we represented one participant, Barry Josephson, executive producer. John represented the other three, the two main actors, and the woman, Kathy Reichs, who was a producer, but also her books were the basis for the character and the show. We filed a lawsuit in Superior Court November of 2015. 15? Right. And then on behalf of Barry Josephson, alleging all the claims that John just talked about, as well as several other non-self-dealing audit claims, sort of your, I don't want to say garden variety, but more just sort of accounting malfeasance, but did involve self-dealing. Everything in the was in the complaint. John filed his complaint a few days later. And the first thing that happened, we were aware there was an arbitration clause in the contract, but it was only in a certain portion of the contract that dealt with self-dealing. So the first thing that happened is that Fox tried to move everything into arbitration, the entire case. We fought that for a while. The judge ultimately said, okay, the self-dealing claims, the claims that sort of impact Fox's self-dealing, those are sent to arbitration at JAMS. The rest of the audit claims are stayed in Superior Court.
Could you explain why there was this disparity or difference? In other words, what was in the contract that said that self-dealing would go to arbitration?
Aaron actually brought the contract.
So there's the claims, the Hulu and international and domestic license fee claims that were moved to arbitration are all governed by a specific contract provision, and I'll give you the provision that kind of sets the self-dealing framework, which is that Fox agrees that Fox's transactions with affiliated companies will be on monetary terms comparable to the terms on which the affiliated company enters into similar transactions with unrelated third-party distributors for comparable programs. And that's part of a broader provision about affiliate dealings, and the JAMS provision itself is set forth in the section of the contract dealing with affiliate transactions. So there's a separate set of audit claims that are more straight accounting claims that are not governed by that provision and ultimately were not moved to
So
arbitration.
you're saying that there was not an overall arbitration provision?
Correct.
Is that unusual?
Yeah, I think it is, and it's
becoming
more,
unusual.
it's becoming more and more so. But yeah, any dispute arising under that paragraph that Aaron just read shall be arbitrated under JAMS. Is what the
Okay,
headline
so
says.
how did you end up with the arbitrator you ended up with? Was that just striking the list?
Yeah, we just did the normal ranking and striking, and we put a lot of thought and coordination between our two firms into it. And I forget, I mean, we probably can't say who we struck, but it was just the normal sort of process. We were actually able to get more bites at the apple because we had two firms. We were able to successfully argue that our firm should get its ranking list, and John's firm should get its ranking list, and Fox should get its ranking list. So we had 2/3 of the say, kind of. But once that all filtered out, Fox didn't strike Peter Lichman. I'm sure they'll never make that mistake again.
Was there trepidation about going to JAMS? I know somebody in this room has written an article about that.
Well, you want to go ahead?
Well, no, I mean, look, I can speak to that. I don't think, from our standpoint, there was no trepidation in terms of going to JAMS. In other words, I've always been of the view, and as John mentioned in the introduction, my background is representing studios and also representing talent. I had litigation for the television division at NBC Universal. I think if you have a good case, and I think if you're right on the contract and you're right on the law, and you have good facts, I see no trepidation or concern about going to have those disputes arbitrated as opposed to having a jury or a judge hear those disputes. So I think that, at least from our perspective, we thought we had a good case. And we always thought we had a good case. And therefore, I think we felt confident that ultimately that case would be decided in our favor, whether it was in front of a judge or a jury. We did file the initial complaint in state court, and without boring you with a lot of the details, the different participants, the different clients had different contractual provisions. Candidly, it was a bit of a mess because though Chad and Aaron are explaining it in a very easy to understand manner, there are different contracts over many years, many amendments. Some of them said that you had a right to an action at law. Others indicated arbitration. Really, there was some question as to which claims should be arbitrated and which should be litigated, which is why we brought them all in front of the state court judge to sort of figure that out and send which ones he felt were arbitrable to the arbitration.
So when you went to arbitration, was there still reserved the claims?
There still are.
Yeah, they still exist.
And what's going to happen to them? Or are you guys done? You got enough money?
No, we're not.
Moving on.
We're not done.
They're stayed still currently, but it's only a matter of time before litigation will move forward on the.
Well, that's new information. So before we go into what happened in discovery and the arbitration, was there an attempt to settle? I presume there were audits?
What you mean, mediation? Like post-filing?
mediation, right.
There was, yeah. I'm not sure how deep we can get into that, but yes, we tried unsuccessfully at least once to mediate.
Okay, so somebody give me a heads up on what happened with the arbitration in terms of how did discovery work, how long did it take, and what were the joys and pain involving it?
The joys.
Did you get to do all the discovery you wanted and all the depots?
We really did.
It ended up not much different than a state court case for discovery. I mean, there were 45 depositions. Whoa. There was an incredible volume of documents produced, lots of motions to compel, and arguments in front of Judge Lichman. And I mean, the discovery was over, I would say,
2 years.
over a 2-year period.